Albert Barsocchini, a regular speaker for the Center for Continuing Education, is a recognized legal expert in e-discovery, international data privacy, and corporate investigations. He was Director of Professional Services at Guidance Software, where he directed all aspects of professional services computer forensic investigations, both criminal and civil, internal investigation, fraud and policy, auditing and compliance, incidents response, e-record audits, and customer data audits, and e-discovery. He was Assistant General Counsel at Guidance Software from 2005 through 2011, where he was an expert on all aspects of corporate e-discovery, data privacy, and internal investigations. Albert served as chair of the California State Bar's Law Practice Management and Technology section in 2000. He is a founding member of the California State Bar Cyberspace Law Committee and currently serves as a special master for the State Bar of California in the search and seizure of legally privileged and confidential matters. He received his JD from the McGeorge School in Sacramento, California. Albert may be contacted at barsocchini@gmail.com.
Hello, my name is Albert Barsocchini, and I'm corporate counsel. And today, I'm going to talk about internal investigations, a look at proactive and reactive responses using technology and process. Internal investigations is something that becoming more important to us these days in the world of corporate governance. Because of all the SOX investigations, because of HIPAA, because of all these regulatory compliance requirements, having a good investigative team is important. I'm also noticing a trend for this investigative team to be under the General Counsel Office, which makes a lot of sense since a lot of times this requires a lot of legal oversight in order to do it properly. Normally, an internal investigation is launched by a corporation to understand and diagnose problems within the corporation. Frequently used to help a corporation avoid or limit possible criminal or civil liability exposure and correct significant problems. It's fact-driven, and the old adage that sometimes the best defense is a good offense. Having a strong investigation team is critical in order to protect your corporation from negative public relations issues, from generating lawsuits, and from just knowing that you have good ethical standards to abide by at your corporation. There's a lot of risks if you do a flawed investigations, and that's why it's important to understand the principles of a strong, proactive corporate investigations. Allegations of obstructions of justice can occur if not done correctly. Damage to the corporation's reputation, damage to employee morale, if not done correctly, in the sense that if a employee within the corporation knows that there is an internal investigation being conducted, that could affect morale within the corporation and also could affect the fact-finding mission itself. And also the creation of negative evidence that may be used in future criminal or civil proceedings if not done correctly. And finally, destruction of evidence. It's so important in the days of digital evidence and also paper evidence that it be conducted in such a way that we can preserve it. As you know, laptops and file servers have information on it that can be easily destroyed, and if that's the case, then you could end up with a situation of spoliation of evidence. The first question that you should ask anytime that you're thinking of doing an internal investigation is it appropriate? And in this case, there are a host of factors that you need to look at. Whether the company was a victim or the perpetrator of the alleged wrongdoing. If the company was a victim of the wrongdoing, is it likely to reoccur? And will the company likely recover much, if anything, in pursuing the wrongdoers? What you're trying to determine is create a balance between doing too many overzealous investigations and really maybe directing this to a HR as an issue that they should take care of instead of cranking up the forces that would do an internal investigation. Other issues include whether the alleged wrongdoing, if true, is placing any third party at risk, whether the allegations are susceptible to verification, and the cost and effort of the investigation as compared with any results it may yield. So very important to look at the checklist, determine if the investigation is appropriate, and if so, then to execute it correctly. A good reality check is a quote that I've seen from Don Rumsfeld when he was Secretary of Defense. You're probably familiar with his saying, there are known knowns, there are things we know that we know, there are known unknowns, that is to say, there are things that we know we don't know, but there are also unknowns unknowns. That is, there are things we don't know we don't know. What is critical in internal investigation is determining the unknown unknowns. In other words, things out there that we don't know exist, but that could come to hurt a corporation. Many in corporate governance believe that going after unknowns is difficult, which it is, and also can be dangerous. My philosophy is that it's important for a corporation to demonstrate strong ethics, to be proactive, and to always be on the lookout for issues that it may not know is there, but is something that any corporation in its position should be looking for. Another adage to remember is to always know yourself. Sun Tzu, who was a Chinese philosopher, said that if you know your opponent's strengths and limitations and know your own strengths and limitations, you can win 100 battles without a single loss. However, if you know neither yourself nor your opponent, you will always endanger yourself in the mission. A classic example is not having a good, strong team in place to be able to go after e-forensic or digital investigations. Technology, as we all know, is going at lightning speeds. And more people out there are very sophisticated in using technology in regard to hacking into networks, or for that matter, trying to go after intellectual property. Therefore, it's very important that your corporate investigation team be at the cutting edge of using the latest technology and have the latest in training. A classic recent example of this is WikiLeaks. After WikiLeaks had done a number of disclosures of corporate information, a company, which I will not mention, was hired by certain individuals to go hack into WikiLeaks. And this company was well respected for its forensic capabilities and its technology. It was a leader in cybersecurity. They were successful in hacking into WikiLeaks. However, another organization friendly to WikiLeaks called Anonymous decided to go after that company and hack into it. And they were able to do it very easily, very quickly, and basically almost took down the company. That is a classic example where the company that was doing the initial hack should have been on its guard, knowing that they were dealing with people out there that in some respects were smarter than they were. And it's always very difficult to look at these unknowns, but it's something that we should all be aware of. Another issue that you need to be concerned with in regard to corporate investigations is privacy. Here in the United States, there is no uniform privacy law that's in place. It's really a collection of state rules that are governing and also some federal rules. We are seeing some legislation to try to make it more standardized on a federal level, but at this time, you must navigate state and federal laws. Some of the particular legislation here in the United States that you need to be aware of is such things as the Video Protection Act of 1988, the Cable Television Consumer Protection Competition Act of 1992, the Electronic Communication Act, the Electronic Stored Communication Act, Fair Credit Reporting, it goes on and on. Having a good understanding of all these privacy laws is critical when you are doing any sort of internal investigation. Most of the large corporations out there today have a privacy officer that oversees corporate privacy issues and makes sure that they are in compliance with state and federal laws. Also, if you're an international company, you have to be aware of data privacy laws in other countries that are a lot more stringent than here in the United States. For example, in Europe, such countries as Germany and France have some of the strongest privacy laws in the entire world, compared to the United States. So if a company in the United States was going to search information from employees in a branch office in Germany, they would have to research and be completely aware of all the privacy rules and regulations in effect in that country. As it could be as simple as going after an address or even a phone number of a particular person within an organization that may be located in Germany that could trigger said adverse consequences and violate laws in those particular regions. So being in contact with the data authorities in those areas and having local counsel to guide you through it is critical when you are going to do an investigation that may reach into other countries. So the EU private data privacy laws is one other area that you need to be aware of. And again, there's other countries that are starting to develop their own privacy laws in Australia, Japan, and also down in South America. The next question is investigate what? So you've decided that there is a major issue that does require some sort of corporate investigation. What do you do? Well, the first issue that you have to deal with is in a large corporations, you may have a variety of information in a variety of places. You may have file servers, you'll have email servers, you'll have laptops, you'll have desktops, you'll have hard copies spread throughout the corporation. How do you go after that information? That is why it's very important that anytime you do investigation, you work closely with the IT department. Having a good communication between legal IT is critical to a successful internal investigation. However, the caveat should be that you should never allow the IT department to conduct the investigation. It is something that should be done by a professional within the organization that is trained to do those types of investigations. Another issue that I'm seeing out there is a convergence of e-discovery, compliance, data audit and security, and internal investigation. And when I'm saying convergence, I'm using in terms of the technology that is used to conduct the investigation and also in the process. And as we all know, e-discovery is really is going after electronic information in regard to litigation. Compliance can be issues ranging from a SOX investigation to a privacy issue to a host of corporate governance problems. And then, of course, data audit and security, being able to periodically audit the data on your network to make sure it's secure and that it is not getting into the wrong hands. All those can be done in a unified approach using similar processes and procedures and technology. So within a corporation, you should always look for technology that can be able to do these varieties types of investigation instead of using separate tools for that purpose. And it also creates a repeatable, defendable process. And that's very important. Any corporate investigation is to be consistent with your process, do it the same way each time, and always to make sure that you have a way to audit that process. Having a comprehensive approach to investigation is critical in order to be prepared for data protection issues where you may have a situation where you have highly important trade secrets that may have escaped the corporate firewalls and got into the wrong hands. How are you going to conduct that particular investigation? Or it could be a problem with a potential hack of your corporate firewall by a third party for a reason to simply play around or to have a more sinister type of motive, such as to create a negative publicity for the corporation or to steal corporate trade secrets. And of course, speed, consistency, mobility, and adaptability is important because anytime you do have an investigation, it must be done quickly because of the volatile amount of information that is out there on email servers and on laptops and desktops. So that is really the primary reason why you want to have a unified approach. Some of the trends that I have seen in terms of corporate investigations are that the board members will demand investigations. As we've seen from past experience, the board is becoming much more active in making sure that corporate ethics is up to industry standard, and that the investigations are done appropriately, and that the results are reported to the board. And we're also seeing less pressure to waive the attorney-client privilege. In other words, we want the companies to have appropriate privilege and be confident that that privilege will be maintained in order that they can share information with law enforcement or with third parties without having to worry about that. We're also seeing more written reports instead of oral, which is critical to any sort of corporate investigation, in other words, to document it. And of course, if you do it orally, there's always the problem when you do may have some oral findings in there that you don't document, is that you could have a lot of hearsay issues come up or a lot of rumors that could hurt the investigation. So it's better to document it in a repeatable, defendable manner. We're also seeing more executives will have their legal fees paid by their employer, which is critical in order for those executives to be able to speak freely and participate in the investigation. And we'll, of course, see more employees be prosecuted for lying to outside counsel. So we're seeing increased difficulty conducting investigations because of the complex enterprise environment that we are dealing with. One of the recommendations that I have is anytime you do conduct internal investigations is that you invest in leap ahead technology, I call it. That is technology that is at the cutting edge, and that is for the sole purpose of being able to keep ahead of your adversaries, people that may have reasons to do harm to the corporation. Simply relying on existing technology is not enough. Things are moving so quickly, as indicated, that you constantly have to be on guard and looking at the latest technology in order to protect your corporate assets. And there simply is not enough innovation. It's very hard to keep up on this, but it's something we all have to do, both at a corporate level, at a federal level, and also internationally. We're seeing more and more instances of cybersecurity incidents where people have hacked into networks and caused problems on an international level for governments and for corporations. Can we prevent wrongdoing by watching the data? Is there a way that we can corral the data into certain locations within the corporate network and be able to watch it? The answer is yes, but it's very difficult to do. So one of the things you do want to do is understand where the information is that is at potential risk and to be able to have a plan in place for protecting it. Can we make the data police itself? In other words, if we share information throughout the corporations, are there ways that we can watermark that data in order to determine where it goes and who has seen it? We are seeing more and more technology that is used for watermarking particular documents and emails so we can easily trace it. And it's something that I think in the long run is a trend that will be very important to protecting corporate assets. At this point, we are still in the infancy in that particular type of technology. So more good, solid, traditional types of investigation is needed at this point until we can get more sophisticated and use watermarking technology. When you begin an investigation, one of the things you always are looking at are triggers. And the triggers are different for each type of industry, whether you are in the medical industry, whether you're in the field of banking, or you're in the field of security. All different types of industries have all separate different types of triggers that you need to be aware of. So one of the things you always want to do is to share and exchange information within the industry so you can all be uniform in those triggers. Because one of the things you don't want to do is to be lagging in a sense and not conducting an investigation when others within that industry would have conducted an investigation that could come back to bite you. So it's better to create industry standards and stick to those industry standards when conducting an internal investigation. Of course, any corporation is always subject to search warrant, government subpoena, or voluntary request for information. How do you deal with it? That is something that is part of doing business here in the United States, and so therefore it's very important to have your corporate investigation team able to respond to a government subpoena in such a way that you can give the information they need without having a problem with your trade secrets getting into the wrong hands. We're also seeing more and more whistleblower statutes, and having a hotline for whistleblowers I think is very important in any corporation and is something that is frankly required. But that should also be part of the whole internal investigation process, is having a channel for whistleblowers and then a way to evaluate the particular allegation and determine whether this has triggered investigation or something that can be handled by HR in another direction. Media reports. A lot of times it's very important for the company to look at what is happening out there in the news to determine whether you need to tighten up your firewalls or be on guard for types of incidences that could put at risk your corporate assets. For example, if you read in the news corporate hacks that are occurring in a particular industry, that's probably a good reason to tighten up your firewalls and be ready to initiate a corporate investigation if you do have to investigate a corporate hack or the disclosure of very valuable IP. Financial restatements, that's another hot area where if not done correctly, that can lead to a lot of negative publicity and legal action against a corporation. So those restatements must always be looked at carefully and made sure that they're totally in compliance. Shareholder demand letter or a civil complaint, of course, is an obvious trigger in a sense for preserving that information for regard to e-discovery. And as you know, any time that you know or should know that litigation is about to occur, you have a legal obligation to preserve the evidence for litigation that could follow. And I think that's the same thing that should occur any time that you have an investigation trigger, is making sure that you're able to lock down that evidence so it can be properly preserved, because at the end of the day, it's highly likely that that can go criminal or civil, and so it's important to preserve that data. And if you haven't preserved that data, then you have the dire draconian consequences of having sanctions, both monetary and in other ways that could hurt the case for the corporation and also give it negative publicity. And of course, auditor concerns in the Foreign Corruption Practice Act is another area. Anytime a corporation does business internationally, they must have in place a process and procedures for auditing the communications and that occur between different foreign entities to make sure that they don't violate the Foreign Corruption Practice Act. And that would require a process that would look at both the digital evidence, the hard copy evidence, and to just periodically be able to audit it to make sure that you're in compliance and no issues has arisen that requires an investigation. So one of the things you want to do is always understand your data location. And what I call this is, what are your crown jewels and where you locate them? Many companies are centrally locating these in file archives, both for email and for e-docs. And that's a good start, but that's only a start. Another thing you need to be concerned of is how that information is protected, in the sense of who has access to it. And you must find ways to be able to label that information and make sure that the people that do have permission to access it can, but more importantly, the people that shouldn't have access to it cannot get at it. And I've seen just lots of examples of corporations that have not followed these simple practices and allowed this information to get in the wrong hands, or simply not know where all that information may reside. Because as we all know, culturally, a lot of people within a corporation like to store information locally on their hard drive. A lot of times they may put that information in a central location, but they may keep a copy on the hard drive, which would be evidence in any sort of investigation, criminal or civil. So it's a cultural issue to get people to centralize their document storage and to be able to enforce those requirements. One trend I'm seeing is locking down the desktops and laptops in so-called thin clients that will not allow a user to store information locally and require them to store information on a central server. I think this is a trend. as we go on to the cloud for purposes of storage, applications, and for better security. And that's why it's so important that corporations have a protocol to data map their information, and then use that data map for purposes anytime there may be a request for production of documents in e-discovery, or anytime there may be internal investigations. You have a place to start. You know where certain information resides, and you can quickly go there. Another thing you must always do is to make sure they're updated, because a lot of times we see a corporation go through the exercise of data mapping and then do not follow up. So it's very important that you follow up with the data mapping to make sure it's up to date and that people are abiding by it through some enforcement mechanism. And that could be as using a software technology that goes out there and scans the network for certain types of keywords that are applicable to certain documents that should be locked down, and make sure they're not in any other location. If they are, then to follow up as an HR issue or as a security matter. But any corporation out there today should be very concerned about their intellectual property. They should be very concerned how the intellectual property is secured, and they should have a mechanism in place to make sure that if there has been a breach of security, that they can quickly investigate that breach and make a determination whether any of that information has been delivered into the wrong hands. We're also seeing a host of evolving corporate threats. Traditional reactive investigations are not enough. In other words, you have an incident and then you fire up your investigation team and you respond to it. However, what we're seeing today is, because of the sophistication, especially in the area of e-docs, of information that's living in digital form, that the bad guy is able to breach a lot of these security things that are in place and be able to get at the particular documents. That's why it's very